Hello and welcome. You're watching RAUS IAS podcast. Now, Indian Constitution has been termed as a transformative document. The meaning of its underlying philosophy, its interpretation and application has been a key area of interest for UPSC in the past, be it GS paper 2 mains examination or law optional, as well as for prelims examinations. Questions related to the term constitution and its various other related terms have been asked quite frequently. So, to deal with matters related to all things constitution, we have with us Mr. Naweed Akhter, who is also a faculty for law optional at RAUS IAS. Hello, sir. Welcome. Thank you for
Hello.
taking time and coming to the office in this sweltering heat.
No problem, Ankit.
Sir, as I was going through the syllabus, I saw in GS paper 2
Hmm.
syllabus the term is given Indian Constitution,
Yeah.
its evolution and its features.
Okay.
Whereas law optional also highlights constitution law and constitution as well.
Yes.
So, from that perspective, as well as prelims examinations, I've seen questions recently appearing terms related to political philosophy and constitution. So, how a student should prepare for their not just their prelims, but also mains and optional examinations from the perspective of reading the Indian Constitution.
Okay. See, even if a person is not preparing for civil services, as a citizen of India, we should know our constitution. Now, having said that, for a student preparing for civil services, even if he or she is not, having law as their optional subject, Constitution of India is a must, and it's also a part of polity and governance under GS2, and there is an elaborate syllabus, as you have rightly mentioned. Now, talking about the various terms, first of all, let us clarify on three important terms I would like to highlight: constitution, constitutional law, and constitutionalism. Right. Now, when we talk about constitution, it is sort of a written document, generally considered as supreme law of the land or grand norm. Now, when we talk about constitutional law, it it's a wider umbrella. In a very generic term, I'm telling you, it's a wider umbrella which also includes the constitution document or a written constitution, maybe unwritten constitution somewhere else, let's say in Britain. Along with it, various interpretations provided by judiciary through its important landmark judgments or any other judgments. So the interpretations or the judicial decisions providing sort of clarity on certain conflicting issues. And we have seen the Indian Supreme Court has, over a period of years, in a way we can say that literally they have enhanced the meaning and understanding of our constitutional provisions along with certain constitutional conventions. So, constitutional law is a wider term which includes the document or the written constitution, various judicial decisions, and also an important part referred as constitutional conventions. Right. So, these conventions are also important because, see, everything is not provided in the constitution. So, to fill those gaps, we need these conventions, or these conventions are being followed over a period of years, right? And because they have been followed over a period of years, and also because we have adopted the Westminster form of government from Britain, hence some constitutional conventions are almost similar, like the Convention of Collective Responsibility, the Convention of having cabinet form of government, and so on and so forth. So that's how constitution and constitutional law, this is the meaning of the term constitution and constitutional law. Now, coming to the third term of constitutionalism. Now, constitutionalism simply means limitation on the powers of the government. There are two possibilities here. There is a possibility that a written constitution may have the essence of constitutionalism, and it's also a possibility that a written constitution may not have constitutionalism. Now, why is constitutionalism important? Because because it basically serves the purpose of a constitution. The purpose of any constitution is to lay down norms, provide rights of citizens, and also establish certain institutions, right? And constitutional morality effectively by observing rule of law, or in the words of Grote, having paramount reverence for the constitutional ethos. And it is here where following constitutional conventions also becomes important. Now, I'll correlate constitutional morality and constitutional convention by highlighting a definition given by Keaton. Keaton highlighted that these constitution conventions are sort of unwritten rules, right? They are uncodified laws. But nevertheless, they are very important. And these constitutional conventions are also observed by the players of constitutional game. And when these constitutional conventions are not observed, it may lead to a fracas or a revolution. So these conventions plays a very important role. In terms of A.V. Dicey, he has, separated Constitutional Convention on two fronts. On one front, there are certain laws which, like, there are legislations, provisions of which can be enforced in a court of law if they are violated. On the other hand, there are unwritten, conventions or certain practices or certain usages. And let's say if these usages or practices are not followed, you cannot generally go to a court of law. So this is where constitutional convention becomes important. However, having said that, regarding the non-enforceability of constitutional conventions, yet there are certain cases in India also where the Supreme Court has highlighted this idea of constitutional convention and stated that some conventions are important also because we have adopted a Westminster form of government from Britain.
So this brings my attention to a previous year law optional question. I think it appeared in 2012.
Yeah.
Now the question itself highlighted that we follow constitutional conventions. But then my curiosity came from the fact that we have borrowed most of the conventions from Britain, but they do not have a written constitution.
Yeah.
However, on the contrary, we have a written constitution. So in this regard, how does constitutional convention becomes important for India for that matter?
I'll give you an example. Right now we are having elections,
Yes, sir.
right? What sort of a government do we have right now? Is it a normal government or is it a caretaker government? Before answering that, just tell me, is it written in the constitution or whatever type of government we have right now during the elections?
No, this is not mentioned.
So there are certain conventions which are being followed. Second example, let's say there is a hung assembly. I'm just giving you an example. Does the constitution provide for the criteria based on which the president will, let's say, call any political party to form the government? It's not there in the constitution, but there have been certain constitutional conventions or practices, and based on that, Sarkaria Commission has given certain
list of norms.
Yes, exactly. So these conventions, as I told you, helps to fill the gaps wherever needed, right? And in the word of Sir Ivor Jennings, he has stated that these constitutional conventions helps or rather provide flesh to the dry bones of law. So basically, it, in a very simple term, constitutional convention fill those gaps wherever required. Coming to the Indian judgments, the judgment is UNR Rao versus Indira Gandhi. And here I would like to tell you and also the students the correlation between Article 74 and Article 75 Clause 3. The first Article 75 Clause 3 says that the collective responsibility is that of the House of the People. What if there is no House of the People? Or what if the House of the People is dissolved? Then to whom does this collective responsibility lies to? Right? Because President has the power to dissolve the House under the constitutional provisions, right? Then in such a situation, what will happen? Or let's say...
That's where I think convention comes into play.
Exactly. Let's go back to 2004, where the government called election 6 months prior to the tenure.
October, September to
Yes,
May.
May. And that's why we are having this election in May after, I think, 20 odd years, right? So, if there is a provision when there is a provision that the Prime Minister and his council advises the President that they want to dissolve the House, then what happens to Article 74 Clause 1? Because Article 74 Clause 1 says that there shall be a Council of Ministers. This is what was interpreted in UNR Rao. The court held, although this case is way back, but the court held that there shall always be a Council of Ministers. And even if a House is dissolved, it will be there in the form of a caretaker government. Why? Because we have adopted the British form of government and the concept of collective responsibility. Again, this term is not written outrightly in the constitution, but because we follow a certain model of governance or certain model of political setup.
That's why the word responsibility
Yes.
has been interpreted as
Exactly. With respect to Article 75 Clause 3.
collective responsibility.
Again, coming to Article 74 Clause 1, it says there shall be a Council of Ministers who shall aid and advise the President, and the President shall act accordingly. I'll ask you this question. what if, let's assume, hypothetically, let's assume whatever advice was given by the Council of Ministers, that advice is unconstitutional. Let's assume. Now, the other part of Article 74 says that whatever advice is tendered cannot be asked in a court of law. Does it mean the president has certain discretion? So this was the case in Shamsher Singh versus State of Punjab, right? But post 42nd Amendment, we all know that the president is bound by the aid and advice, right? Exactly. So again, we have to understand that through these constitutional provisions and also the kind of setup we have adopted from Britain, here there are certain importance of constitutional convention. I'll give you another example of constitutional convention, which has been followed. And this is the third judge's case, right? The third judge's case basically established the collegium system of appointment for judges. And ever since, judges have been appointed through the collegium system. And in the fourth judge's case, this aspect was highlighted, or this was challenged, that because the government came up with the NJAC, but NJAC was declared as unconstitutional, and the system of collegium still
collapsed.
Collegium still, it still continued. So can we then say that collegium is not provided there in the constitution, but it has been followed over the last more than 25 odd years, right? So there is certain consistent usage. So one aspect is consistent usage. Second aspect is people follow that, a consistent usage or a custom, because they believe that it has a force of law. And not following, would entail denigration in such constitutional practice. So that's why there are constitutional experts and scholars who do observe these constitutional game or these constitutional things happening around the world. And it is here where following these constitutional conventions becomes very important. Although they cannot be taken to a court of law because there is no as such a written rule or something, yet courts have taken note of constitutional conventions in n number of judgments.
So this brings my attention to the importance of Indian judiciary, especially the apex court, in reading and interpreting the provisions of the Indian Constitution.
Yes.
And we have seen the various tenets of the Constitution have been, in a way, evolved because of these judgments.
Yes.
Be it 1974 judgment, 1973 or 74. Keshav and Bharti.
Okay, 73.
73. So Keshav and Bharti court held that this should
Basic
be a
structure
basic structure of the Indian Constitution. And in 94, in SR Bomai case, Supreme Court highlighted that secularism is also a part of basic structure.
Yes.
So this highlights the importance of Indian courts vis-a-vis how Indian Constitution has transformed. And this also becomes a topic for UPSC GS paper 2 syllabus, where questions are now appearing on various Supreme Court judgments and what these judgments highlight for a students to write. So how these answers vis-a-vis from a GS paper 2 perspective on one hand and from law optional perspective on another, how these answers differ. Should a student must quote these Supreme Court judgments and its interpretations, or can they avoid for, say, GS paper 2 syllabus?
See, talking about these questions, first thing, to understand a topic, you have to understand it conceptually. Okay? After that, after you have understood a topic conceptually, then comes the answer writing, application of that concept. Now, when we talk about, let's say, secularism from the perspective of GS2. Now, as you have seen, that questions have been asked with respect to comparison with France, right? How is secularism in France different from that of India? Or in general, how is Western secularism different from the Indian concept? On the other hand, in the law optional, questions have been asked, or the term secularism has been tagged along with the terms such as multiculturalism, pluralism, right? Or state being neutral to principal distance concept. So conceptually, there is no difference. If you ask me how to understand secularism, is it any different from GS2 or for prelims or for law option? No, it's the same. The concept is same. But yes, the presentation would be different. I'll give you an example. Now, secularism, when we study from a GS2 perspective, very simply what we study, that Western notions of secularism, there is a complete separation between the state and religion, or church and state, right? But in India, this is not so. Why? Because of Article 25. Now, what does Article 25 says?
Practice,
It
profess,
talks
and
about three
propagate.
P's: practice, profess, and propagate, along with the fourth aspect of freedom of conscience. However, can the state regulate these three P's and freedom of conscience?
There comes the essential religious practices and
First, on the
secular
first hand, that comes the later stage. On the first hand, state can regulate on grounds of public health, morality, and public order, right? Other than that comes the two parts of secularism.
one is
One
essential
is essential
religious
religious practice. Now let's understand essential religious practice, which was first highlighted in Shirur Mutt case in 1954 by the Supreme Court, and that test has been followed in all all important judgments which you have:
most recently being Sabrimala.
Sabrimala judgment, Shaira Bano judgment, Triple Talaq, and other judgments also. So, what is this essential religious practice test? Any practice without which the religion won't be complete, without which
An essential.
such basic structure, this is what has been highlighted by the Supreme Court, the basic structure on which the superstructure of the religion stands. So if you take away one of the basic structure, the superstructure might fall. So essential religious practice are those essential parts of a religion or being practiced that if you take away that essential part, then it's as if the religion is not being followed. On the other hand, there are secular practices or other practices associated with the religious practices,
Which not necessarily is the basic.
which is
tenets
not
of the
which is not part of essential religious practices. Those are the practices which can be regulated by
like
state.
salaries of employees of the
Temple, perfect. Let's say a temple or a church or a mosque has some funds they want to invest.
invest those funds.
So, can the government regulate those? Absolutely, because those are secular practices or associated practices, not essential religious practices. So, what Article 25 guarantees is the freedom of three P's: profess, practice, and propagate, plus freedom of conscience with respect to the core part of the religion. Essential part of the religion, but not secular part of the religion or secular activities. And that's why if you go further into Article 25, it says that state can also regulate their political aspect, financial aspect, or economic aspect, or other aspect as contained in Part 3. Now, this is where Sabrimala judgment becomes important, because the moment we say as other aspects contained in Part 3, Part 3 means fundamental rights. Now, talking about Sabrimala judgment, here also the question was same, that restricting menstruating women into the temple, is it an essential part of the religion? And the court answers was no, because it also impacted this other part in Part 3, that is equality and basically gender equality. And it is here also the Supreme Court quoted the concept of or highlighted the concept of constitutional morality, because ultimately it's ultimate reverence of the constitution as quoted by Grote. So ultimate reverence to what provisions of the constitution? Article 14, Article 15, Article 21. And these essentially forms the essence of liberty, right? And also equality or lack of discrimination. So that's why this essential religious practice test becomes very important. Same was in Shaira Banu when the Supreme Court was discussing whether ban of triple talaq, is it okay? The court said it's not an essential religious practice. Similarly, with respect to M.H. Qureshi versus State of Bihar regarding sacrifice of cow, the court held that it's not an essential religious practice of Islam, hence can be regulated under Article 25 Clause 2. So we really need to, again, we need to understand this concept that what is an essential religious practice and what are other practices or other secular practices. So other secular practices or associated practices which are not part of essential religious practices can be regulated, right? So I hope, so now coming to answer writing with respect to GS2 and law optional. It depends. I'm saying this because of late we have seen even in GS2 that questions have been framed with respect to writing those case laws.
IR Coelho in 2016.
Yes, very recently, constitutionalization of environmental issues.
2022.
So in case the question is asking specifically for case law, then you can highlight some of these landmark judgments. Now, coming to law optional, if you don't write these landmark judgments, you won't get any marks. So, your whole, again, your whole structure of your answer depends on these landmark judgments. Whereas here, unless asked for specifically, these landmark judgments adds as a value addition point or value enrichment point. But again, no matter how, let's say you have written those case laws, but you're not highlighting this basic concept of difference between essential religious practice and secular and associated practices, then I don't think much marks would be given to you.
I think so. We should conclude our today's discussion with. So this was all for today's discussion. Stay tuned for more content. Until then, I bid you a very good night.